Hello everyone, today we are going to see about quasi-contract. Quasi-contracts are defined to be the lawful and purely voluntary acts of a man from which there results any obligation whatever to a third person and sometimes to a reciprocal obligation between the parties. It is not legitimately done, but the terms are accepted and followed as if there is a legitimate contract. A quasi contract is not a contract at all because one or the other essentials for the formation of a contract are absent. It is an obligation imposed by law, not by agreement of the parties. Courts created quasi contracts to avoid the unjust enrichment of a party in a dispute over payment for a good or service. In some cases, a party who has suffered a loss in a business relationship may not be able to recover for the loss without evidence of a contract or some legally recognized agreement. To avoid this unjust result, courts created a fictitious agreement where no legally enforceable agreement exists. For example, X supplies goods to its customer Y, who receives and consumes them. Y is bound to pay the price. Y's acceptance of the goods constitutes an implied promise to pay. This kind of contract is called a tacit contract. In this very illustration, if the goods are delivered by a servant of X to Z, mistaking Z for Y, then Z will be bound to pay compensation to X for their value. There are some features of quasi-contract. It is imposed by law and doesn't arise from any agreement. The duty of the party and do not promise of any party is the basis of such contract. The right under it is always a right to money and generally, though not always, to a liquidate sum of money. The right under it is available against specific person and not against the world. A suit for its breach may be filled in the same way as in case of a complete contract.